you. Good morning and welcome to the Court of Appeals. I'm Judge Donna Stroud, head of the panel today, and we have to my right Judge Walter Collins, to my left Judge Carolyn Thompson, and we have, some of y'all may have seen the calendar earlier. There were 2 cases on the calendar originally, but now there's only 1 case on the calendar. So we just have the 1 for argument today, and it looks like our attorneys are in place and ready to proceed on that. And have you already set the time for the, okay, very good. Then we are ready to proceed.
Good morning, Your Honors. May it please the Court. My name is Sarah Holliday on behalf of the defendant appellant, Mr. Farook. I've reserved 5 minutes of my time for rebuttal. I expect that we'll spend the bulk of our time today talking about the speedy trial issue, but I do also want the opportunity to express the malice issue and, of course, welcome any questions you may have about Harbison. As we all know, the 4 factors in the Barker analysis are the length of the delay between arrest and trial, the state's reasons for that delay, the defendant's assertion of right, and any prejudice the defendant may have suffered. And the remand court in this case correctly identified that standard, but this court should reverse and vacate because the remand court applied the standard in a manner contrary to precedent. I want to focus on 3 main errors in the remand court's order. First, the court failed to weigh backlogs in the court system against the state. Second, the court failed to properly assess Mr. Farook's assertion of his right to a speedy trial. And third, the court failed to properly weigh the prejudice that Mr. Farook has shown. Had the remand court properly weighed the evidence before it, it would have concluded that Mr. Farook was denied his right to a speedy trial. At the remand hearing, the state put forth a great deal of evidence demonstrating that the courts in Rowan County were overburdened and underfunded. But be that as it may, our Supreme Court in Farmer and the U.S. Supreme Court in Barker and Strunk have made clear that when a defendant's case is delayed because the state has underfunded its courts and prosecutorial agencies, the period of delay caused by those backlogs must weigh against the state. The remand court, however, not only failed to weigh the backlog against the state, it weighed that backlog against Mr. Farook by finding that the backlog justified the 6-year delay and outweighed any presumption of prejudice or negligence. It's the state of North Carolina's responsibility to fund the courts, the prosecutors, and the crime lab so that justice may be done. And the state's failure to do so cannot justify the denial of a defendant's right to a speedy trial. In addition, the remand court further erred by failing to hold against the state portions of the delay which could have been avoided by reasonable effort. For example, in 2012, when the state's rush request for DNA testing was returned because they'd failed to include Mr. Farook's available sample, the state could have easily avoided the 2-year delay that followed by immediately resubmitting their request. In addition, when the results did come back, the state waited another full year before acknowledging that it didn't have the time and resources to address Mr. Farook's case in a timely manner, and then they called in the resource prosecutor. This, too, was a delay which could have been avoided by reasonable effort. Now, it's true that the state was trying some cases during this time. If you look at State's Exhibit A, beginning at Doc X2, you'll see a list of their jury trials. And what you'll see is that they were making choices about what kind of cases to try. In 2012, Rowan County tried 1 murder case, which had been pending for 2 years. In 2013, they tried 1 murder case, which had been pending for 2 years. They tried no murder cases at all in 2014 or 2015. Furthermore, none of the cases tried by Rowan County in the period between 2012 and 2018 had been pending as long as Mr. Farook's case had been.
Do we have any guidance about how much we should weigh this type of backlog from our courts? Is it heavily? Is it mildly? Is it, can you speak to that?
Certainly, Your Honor. The guidance is that it weighs, I would say, moderately to slightly against the state. It's not a heavy weight, but it is weight that is against the state.
And do we have case law that says that?
I believe that is what it says in Farmer. And I believe Barker also says, recognizing this is not a problem that's created by the district attorney's office, but nonetheless, it must still weigh against the state. I think that suggests that it's a moderate level to a slight level of weight.
And so do we need to look at the neglect or the willfulness in what's going on in the court system and why there's a backlog?
Well, I think that one can infer from the circumstances of this case, I think one could infer that. Certainly, there's neglect in failing to fund the court system generally. There's also neglect in failing to reach this case, which the state was aware had been pending for longer than any of the other cases it elected to try. And there's also neglect, of course, in failing to take reasonable steps to secure the DNA testing that they claimed was necessary to bring this case to trial. So what State's Exhibit A suggests is that what we have here is not a docket clogged with murder cases, as this court has seen before. It's a docket clogged with misdemeanors, and that defendants like Mr. Farook, who are charged with more serious crimes like murder, are forced to either plead guilty or wait an exceedingly long period of time to have their cases tried. And when the state makes decisions about what cases to try and when, their responsibility for any delay that may occur must fall upon them. And therefore, the remand court erred in failing to find that this factor weighed against the state.
Was Mr. Farook incarcerated during this whole period?
Yes, ma'am. Mr. Farook was incarcerated for 2,302 days. As to assertion of right, the remand court found that Mr. Farook did not assert his right to a speedy trial at any time prior to 2018. The court could only reach this conclusion by ignoring the evidence before it. The record contains evidence that Mr. Farook made multiple attempts to draw attention to his case to protest the fact that he had been incarcerated for so long with nothing happening. He first wrote to the Superior Court in 2013, saying he'd been incarcerated for a year, he hadn't received any discovery, he didn't know what was going on. Could the court please help him? And the Superior Court judge responded with a form letter saying that because he was represented by counsel, he couldn't contact the court. And so Mr. Farook obeyed that directive and didn't contact the Superior Court again. In 2016 and 2017, he reached out to the federal courts. Again, he says, I've been incarcerated for 4 years. My case hasn't gone to trial. I don't know why. Later, he writes again to say, new charges have been added. How is this fair? And he says there are other defendants incarcerated with him who are experiencing the same burdens, incarcerated for 3, 4, 5 years without a trial. And he asked the federal courts for help. And the federal courts say, given the status of the case, that there's nothing they can do. And the state was aware of these efforts. Both the judge's 2013 letter and the magistrate's orders from 2016 and 2017 were served on the district attorney. And yet they failed to do so much as schedule a status conference in Mr. Farook's case. He wasn't in court at all between 2012 and 2017. He had no opportunity to tell the judge about his concerns.
Is it true that between this time he filed no formal motion for a speedy trial violation?
Yes, Your Honor. No formal motion for a speedy trial was filed until 2018 by Mr. Farook's lawyer, Chris Sees. However, there's ample precedent, first of all, that that's not a waiver, and second of all, that even when the defendant does belatedly assert his right, it is still possible for him to obtain relief. If you look at Chaplin, in that case, the motion was filed a month before trial, and this court still determined that Mr. Chaplin's right to a speedy trial had been violated.
So does our court look at these sort of unofficial assertions of the right as weighing in favor of asserting the right, or do we just not look at them and wait until the official one's filed?
Well, certainly the latter is the approach that the remand court took, but I think that fairness would require this court to consider the whole picture. It's simply not fair to say that Mr. Farook was doing nothing. He was doing everything that he could as a man with a 9th grade education and no access to any, real ability to present his legal case.
Could this case law support this fairness, I think, approach to looking at it? Do you have any cases that have done so?
I think certainly, for example, Barker, going back to Barker and talking about why prosecutorial delay should weigh against the state, the court says, ultimately, because it's not the defendant's fault, and I think that's an approach to fairness. So, excuse me.
So we don't have any case law that has specifically looked at this unofficial assertion of a right as weighing in favor of having asserted the right?
Not to my knowledge. And one thing that I would note about the assertion of right in this case, had the state been having status conferences, had there ever been a motion to continue and a resulting hearing, then Mr. Farook would have had the opportunity to make the record that's missing in this case, but the unique circumstances of this case are such that he just never had that chance.
And he was represented by counsel during this time, right?
Yes, from 2012 to 2017, he was represented by James Davis.
Okay. So is that more of an IAC claim than a speedy trial violation claim?
I would say not, Your Honor. It's certainly, there may independently be an ineffective assistance of counsel claim, but I don't think that prevents this court in any way from addressing the other issues with the case.
So why were there no status conferences? Was this just the practice there? Didn't the rules require those?
There was no formal requirement, to my knowledge, in Rowan County that there be regular status conferences in a case. And I apologize, I forget the exhibit number, but one of the exhibits that the state put in was a calendar of when Mr. Davis's cases were on. And if you look, you see that many of his clients are having status conferences. There was one I saw who was on 15 times before he had a trial. But for some reason, Mr. Farook just never had one. So continuing with the assertion of right, the remand court refused to consider the evidence that Mr. Farook did not meet with his assigned counsel until 2017, nearly 5 years into the case. Now, the evidence before the court came from both the state and the defense. The state admitted exhibits B48, a letter from Mr. Farook to the clerk asking whether any motions to continue had been filed in his case, because he didn't know. The state also admitted B50, Mr. Farook's pro se speedy trial motion, in which he asserted that he had not seen his attorney for 57 months, that during that time he was not informed of his rights, and he did not agree to any delays that counsel may have affected during that time. There's also Defense Exhibit 1, the federal motions, in which Mr. Farook indicates that he wasn't aware of the possibility of additional indictments until he met Mr. Davis in 2017. There's Defense Exhibit 2, the jail log, which demonstrates that there were 0 legal visits for Mr. Farook between his arrest in 2012 and the beginning of plea negotiations in March of 2017. There's the testimony of Mr. Farook's family, that he didn't know what was going on with his case. And frankly, there's Mr. Davis's testimony from the prior hearing, in which he goes into great detail, completely unfettered, about everything that he did in this case. And there's no contact between him and Mr. Farook until March of 2017. The right to a speedy trial is a fundamental right, one which cannot be waived without some action from the defendant himself. In State v. Groves, for example, most of the 2-year delay in that case was caused by the 13 continuances that the defendant himself sought. There are other cases where the defendant actively participates by absconding, by forcing a change of counsel, by threatening his attorney, but we have none of that here. All we have is a defendant who was unable to get himself or his case into a courtroom for 5 years. He hadn't seen his attorney. He tried to contact the Superior Court. He tried to contact the federal court, and at every turn he was shut down. While a delayed assertion of right would ordinarily weigh heavily against the defendant, under the unique circumstances of this case, that weight should be only slight. I would further note, the state contends that Mr. Farook is trying to bring a claim of ineffective assistance of counsel on direct appeal. He is not. If anyone is asserting that Mr. Davis was to blame here, it's the state. They're the ones who presented all the evidence of Mr. Davis's heavy caseload and alleged that this caseload impacted the ability to schedule trial. Mr. Farook is not arguing in this proceeding that Mr. Davis rendered ineffective assistance of counsel. He's simply arguing that the evidence before the remand court, much of which the state produced, justifies a deviation from the usual presumption that an attorney acts on behalf of his client. So finally, the belated assertion of the right to a speedy trial is not a barrier to relief. The defendant and chaplain, there was a 3-year delay in that case. The case was calendared over 30 times, but never actually made it to the trial court. And I would note that in this case, there's a 6-year pretrial delay that makes a handful of appearances on the administrative calendar. But Mr. Farook is not in court at any time between 2012 and 2017, and his case is not called for trial until October of 2018. What Chaplin suggests is that even if Mr. Farook made no effort to assert his right to a speedy trial until 2018, it is still possible to find that he was denied his right to a speedy trial. Finally, turning to prejudice. The remand court found that Mr. Farook failed to establish any prejudice at all. The only form of prejudice meaningfully considered by the remand court was actual prejudice, and this is clearly contrary to the language of Barker, which says that there are two additional forms of prejudice that must be considered. The first of these is pretrial incarceration, and the second is the anxiety and concern of the accused. And in this case, there was unrefuted evidence of both. In cases like Webster, where the defendant is only incarcerated for 5 days, that carries very little weight. But Mr. Farook was incarcerated for more than 6 years, and every one of those 2,000 plus days was prejudice that the remand court has ignored. The remand court implies that being in jail was not prejudicial to Mr. Farook because he'd been incarcerated previously. What an absolutely dismal view of human life to say that 6 years of anyone's life has no value at all. Mr. Farook was a pretrial detainee. He was presumed innocent. He had the same rights as you and me. And none of us would say that the last 6 years of our lives were worth nothing. Furthermore, this is contrary to Smith versus Huey, in which the Supreme Court found that all three forms of prejudice were present in a case where the defendant was already incarcerated on another offense. Similar results were reached in Dickey and Wilkerson. The remand court also ignored the evidence that the longer Mr. Farook was incarcerated, the more depressed and anxious he became. He's worried about why his trial had not been scheduled. He was saddened to be unable to support his family in their time of need. He lost his home and his job, and he lived for 6 years under the cloud of these accusations. And by failing to give this evidence any weight, the remand court plainly misapplied the Barker analysis. The remand court further determined that the imposition of new charges several years into the case was not prejudicial because those charges were based on the same conduct as Mr. Farook's original charges.
So just,
Yes.
you do not have to show any prejudice to your defense in order to have this weigh in your favor?
Correct. It's well established in Barker, Doggett, Moore, Farook too, that a showing of actual prejudice is not required. The remand court determined that the imposition of new charges several years into the case was not prejudicial because those charges were based on the same conduct as Mr. Farook's original charges. And here I would point to Elwell. In that case, there were new indictments lodged 19 months after the defendant's arrest, and the U.S. Supreme Court found that this was not prejudicial because those new charges actually carried a lesser penalty than the charges that Mr. Elwell was already facing. So it stands to reason here that where new charges come 5 years after the defendant's arrest, and they expose the defendant to a significantly greater sentence, that is prejudice. As this court observed in Farook 1, it would not have been possible for Mr. Farook to receive a life sentence from the charges as they stood from 2012 to 2017. And I would note that ADA Banks indicated in his rush request to the SBI lab that he was prepared to try this case in October of 2012. Now that didn't happen because Mr. Banks hadn't submitted the DNA sample, but if it had, Mr. Farook would be in a very different position today. Furthermore, the remand court appeared to find its determination that Mr. Farook did not present evidence of actual prejudice to be fatal to his speedy trial claim, and as we've discussed, actual prejudice is not necessary. Had the remand court weighed these factors properly, I think its analysis would have looked something like this. As to the length of the delay, 2,302 days passed between Mr. Farook's arrest and his trial, and so therefore the first factor weighs heavily against the state.
Can we talk about that first factor? Sorry, I know you're going to give
Certainly.
an interview. So I know that we've got a presumptive prejudice if we get to a year, and that essentially seems like a threshold inquiry, correct? Mm-hmm. So once we get past that threshold, do we consider the length of the delay again in this weighing process, or is that simply a threshold and then we're done with that?
You consider the length of the delay again, Your Honor. As you get beyond a year, further out into time, a couple of things happen. First, you get a presumption of negligence. Second, you get a presumption of prejudice. And then, in this case, because it was 6 years and not 1 year, that's got so much more weight. Does that make sense? And of course, it adds also to the weight of the incarceration. It adds to the, the probability that some difficult to specify error, which affects, this comes up in Doggett when they're talking about how sometimes actual prejudice is hard to articulate. And the longer that a case goes on, the more that is true.
Okay, so we have these Barker v. Wingo factors, and we look at it first to see if we even analyze them. And once we analyze them, then we start all over again with the length of the delay.
Right, that continues to get weighed in the final analysis. Barker's clear that you must weigh all 4 factors together. So, length of delay heavily against the state. And then as to reasons for delay, the primary reason advanced by the state was the backlog in the courts and the crime lab. And furthermore, significant portions of those delay could have been avoided by reasonable effort. So again, this factor weighs against the state. As to assertion of right, while a formal speedy trial request was not made until 2018, Mr. Farook made earlier efforts to draw attention to his case, and there was evidence that any inaction or acquiescence on the part of trial counsel was without Mr. Farook's informed consent, and so this factor can weigh only slightly against Mr. Farook. Finally, as to prejudice, Mr. Farook was incarcerated for the entire pretrial period. This weighs against the state. Mr. Farook experienced increasing anxiety, depression, and worsening health, and this weighs against the state. And Mr. Farook was prejudiced by the imposition of additional charges 5 years into his case, and this weighs against the state. So at the end of the day, 3 of the 4 factors weigh against the state. Had the remand court properly assessed the evidence before it, properly weighed the evidence, and considered each factor, it would have reached the conclusion that Mr. Farook asked this court to reach today, that he was denied his right to a speedy trial.
I have 2 questions. So I see you're doing the balancing. What kind of balance is required at the end? Is this a 51-49 in favor of defendant and he wins? Is this you got to have a whole lot more in favor of one side or the other?
I don't know that that's been clearly stated, Your Honor, but yes, 51-49 would be what I would say if the evidence is at all in favor of the defendant. There are some cases that talk about, even slight prejudice must weigh in favor of the defendant. So I think even a slight tip in the scales must weigh in favor of the defendant for speedy trial purposes because it is such a fundamental right.
Okay, and what are we looking at in terms of standard review of the trial court's decision? Are we looking at this de novo?
Yes and no. There's the initial inquiry, whether the trial court's findings of fact are supported by the evidence and the conclusions of law are a proper application of the law to those facts. But also within that, this court will assess the evidence de novo. So just to say a few quick words about malice before I take the rest of my time. Because this case involves neither evidence of impairment at the time of the crash nor evidence that the defendant was deliberately recklessly driving, it is different from every other case of vehicular second-degree murder considered by our courts. In the context of a vehicular second-degree murder, the question is whether the defendant had the intent to perform the act of driving in such a reckless manner as reflects knowledge that injury or death would likely result. Thus, it requires both that the defendant intentionally drove in a particular manner and also that injury or death was the likely result of that act. And in this case, it's alleged that Mr. Farook was driving while license revoked. This alone cannot support second-degree murder because it is not an act likely to result in serious injury or death. It was also alleged that Mr. Farook was driving left of center. However, this too cannot support second-degree murder because all the evidence in this case was that Mr. Farook did so unintentionally, and thus he did not have the intent to perform the act of driving in a reckless manner. As the prosecutor conceded at the remand hearing, there was not evidence that Mr. Farook was impaired at the time of the crash. There was also no evidence that he was fleeing the police, speeding, running stop signs, or intentionally going out of his lane to pass other cars when the crash occurred. And that's what distinguishes this case from others like Bethia, Byers, and McBride. In each of those cases, in addition to driving while license revoked, the defendant was intentionally operating his vehicle in a way that put others at risk. And because the state's evidence was insufficient to prove malice, the trial court erred in denying the motion to dismiss second-degree murder, and Mr. Farook's conviction for second-degree murder should be vacated, and his conviction for obtaining the status of a violent habitual felon should be overturned.
So how do we look for intent for this malice? If somebody's driving left of center, do we have to actually have some sort of physical or evidence that they didn't mean to or they meant to? Can't we infer that?
Well, under the circumstances of this case, I'm not sure that you can. All the evidence, the state called in a trooper to do an accident reconstruction. And the trooper's testimony was that Mr. Farook sort of accidentally veered off to the right side and then overcorrected, and the car started to slide and slid over into the left lane, and that's when the accident occurred. The trooper also testified there was no evidence that that was intentional. And so given that, I don't think the evidence here supports intent. And if you have a traffic accident without intent, then you move into asking whether it's involuntary manslaughter, misdemeanor death by vehicle, or not guilty. Okay, I'll reserve the remainder of my time.
All right, thank you.
May it please the court, John Congleton for the Attorney General's Office for the state. It's our contention that the trial court weighed this appropriately, specifically starting at the beginning, speedy trial. The framework is pretty well established, Barker versus Wingo, all the other cases. In this particular case, the delay was 6 years. That triggers the Barker factors. And once it does that, and that's pretty well clear, I think the Barker, those cases say once it approaches a year, that's going to trigger this. So we're going to presume that there's some prejudice such to trigger the court to look at why this delay is there. And it then sets out 3 factors that you look at to determine that. And the first one, of course, is the reasons for the delay. Now, in this particular case, the state put on a lot of evidence about there was a backlog of cases. There were, funding issues or whatever was going on. But in any event, there's all these cases out there. The state even indicated that it's difficult. They talked at length about how when you have like a trial week, you can legitimately only do maybe 1 or 2 things. There's other DAs and cases competing. They talked about the fact that you have some cases that are clearly for trial. Now that's going to come up later in this because one of the factors that sort of pushes Farook's case down the road was his counsel, Davis, for instance, was very busy, had a lot of murder cases with Barrett Pompler, who was the DA handling it at that point. And those cases are also applying pressure because those large murder cases were specifically for trial. They were not situations where, and that was the testimony, we knew they were for trial. They weren't still doing plea bargains. They weren't still discussing anything. So those cases are chugging specifically toward a trial. And they're huge cases. I think the Marlene Johnson case we're talking about would take 2 or 3 months to try. So you have these pressures out there. Furthermore, there's no requirement that a court district, specifically go in and try cases in the order in which they're received. That's simply not efficient because different cases of different size and different complexity are going to have different requirements. Also, you're going to have situations like we contend here where you may have a defendant who's not interested in a trial right away. They may want to involve serious plea negotiations. And that's what was elicited by the state's evidence here was that early on, they're talking to Mr. Davis after he gets appointed. I want to say it was August of 2012. And he initially basically says, hey, look, well, he files for discovery. He gets discovery. And he's like, I need to look this over. I need time. The DA had testified that, early on, we're like, hey, if we're going to go to trial on this thing, then we're going to go the violent habitual felon. We're going to go with all these other things. So
that was in 2012 that he had asked for some time to review the discovery, correct? Or no?
I think it was 2013.
Okay.
I think it was early 2013 when he did that because he had to get the discovery back. But it was early on he'd gotten that. Okay. And he said, I need more time. And The district attorney also, Mr. Poplar, also testified that, and I believe that the testimony was that, and he had this conversation with Mr. Davis, I don't put cases on calendars just to put them on calendars. I put them on calendars when there's something to discuss or there's something we need to do, or if you request it to be on there, if you have something to do. If there's nothing to be done in the case, I'm not simply going to put it on there. But it was also very clear testimony that he told Mr. Davis, if you want to put it on there, just ask. He testified that in many cases or other cases with Mr. Davis was very clear with him. This one's going to be for trial, or I need to put this on to a calendar so we can discuss X. And they always did that. So you have a situation where you have a DA who's handling a case, and a lot of cases, and even other cases with Mr. Davis, where Mr. Davis isn't saying, hey, we need to put this on a calendar.
And just to be clear, the DA has total calendar control, correct?
I'm not going to say total, but I will say that generally speaking, the district attorney does control what they calendar. I believe that a defendant could very easily, or an attorney could very easily move the court, file a motion saying this needs to be calendared, or something needs to be addressed. There's nothing stopping a defense attorney from filing a motion with the court going, let's talk about this.
Can a defense attorney put something on the court calendar?
Well, I don't believe that they can put it on there. I think in that instance, they would have to ask the court to intervene. I don't think they themselves control the calendar.
Okay.
But
So during this time, the DA didn't put it on the calendar even though year after year after year was passing?
well, it did come on at various times, and like one of them was, you had this situation where in 2015, the blood results come back, and they go, hey, wait a minute, there was DNA along with this, what's going on? And that was when Ms. Cook, I guess, contacted the lab and said, hey, what about the DNA? And then the DNA comes back in July of 2015, I think. When the DNA comes in, Mr. Poplar puts it on a calendar at that point to talk about, hey, we've got the DNA back, what are we going to do? And he puts it on the calendar at that point. And when he puts it on the calendar, they have this conversation. I want to say it's transcript pages 184, 185, in that range, where he says, I know that he's going to need to look at the DNA and this, that, and the other. And the testimony is, we agreed to remove it off the calendar and continue talking. At no point does Mr. Davis ever ask to put this back onto whether an admin calendar to talk about anything or a trial calendar. He's got the discovery. They're still talking about pleas. And that's also sort of clear in the testimony that that's what's happening. They're doing these informal plea discussions. There's even talk about that there was, I want to say that Mr. Davis had suggested a plea that would result in 8 years. Mr. Poplar had said, no, that's not going to be enough. I've got, two deceased, people here, the family members just would be insulted by that. So we know that there's these, again, talks about a plea going on. And the trial court properly made findings about that in the sense that it says, I'm not going to hold the defense's delays or the defense's sort of failure to press this case along against the state. And that's what's interesting. The other interesting thing about the reasons for the delay here is that there is an inherent, it's ultimately the state's responsibility to prosecute cases. Of course. But by that same token, what happens if you have a case like Barker, and to a degree like I think you have here, where you have a defendant that's not seeking a trial? You have a defendant that's seeking a plea. And that also, we'll talk about that in a minute, it's going to go to the assertion of the rights. But sort of in this case here, the state's pushing other cases. They testify, we didn't do anything. We weren't intentionally pushing his case back.
Do plea negotiations ever happen when a case is on the calendar for trial?
I assume they do, absolutely.
So it's not a hindrance that there are plea negotiations, you could put it on the calendar anyway, correct?
It's not a hindrance, Your Honor, that there's plea negotiations going on. But I think the fact that a defendant is still entertaining plea agreements is evidence that he is not bent on a trial. He's not saying, no, not taking any deals. I'm innocent. Let's go.
Can we back up a little bit and talk about the DNA evidence? So I've read in your brief that It wasn't ADA Banks that negligently failed to submit the DNA sample to the crime lab. It was the State Highway Patrol that was supposed to do that, correct?
That's my understanding from the document.
And the State Highway Patrol is the state, correct?
It is.
So, and the crime lab took a while, I guess, to get the results back, correct?
Yes,
And the crime lab is the state, correct?
that is correct.
So we're not just looking at the DA, but we're looking at the state. So it's not the defendant against DA Banks, correct? We're looking at the state's failure,
Yes.
correct? So it all comes together regardless of which actor in the state failed to do whatever they were supposed to do.
Well, it's ultimately the state's responsibility in that regard to test the evidence and that. But again, we're looking at this first factor of the reasons for those delay, and, pardon me, the reasons for that delay.
But I just want to make sure that we're all looking at the same actor, which is the state
Yes,
as a whole.
I'm not arguing in any way that the defendant has this responsibility to get the DNA tested against him. To my knowledge, they themselves didn't request any DNA testing. The state did, and it is the state's lab, and it is the Highway Patrol that submitted it, not disputing that.
Okay.
But the delays that are going on here is, there's not really any, they're not trying to sidestep that. You know, they've sent it out there. Poplar even talks about that at that point in time, you know, it's taking 2 or 3 years to get labs back.
And that's the state, right? Again, taking
Sure.
2 or 3 years to get the labs
Absolutely
back.
it is. But we don't get into the reasons for why that is. But the point is, that's happening. And again, defendant's not asking for a trial. And so his counsel's not even asking for it really to be put on a calendar.
So how much of that delay was kind of what I'll call the normal delay, obviously, because they were behind, and how much was delay from not getting the sample to the lab properly?
I don't think it's really clear from the evidence what that delay is, because I think we sort of have to, we're getting into speculation at that point, because when the lab gets it, there's not a lot of talk really about exactly how long or what the lab's priorities are.
Well, I mean, obviously, the lab can't do anything till they get it. We know that.
Well, yes, that's
So
correct.
that's how long?
I want to say, well, again, there's blood and there's DNA. They're
Right.
sort of two separate things, but I would have to look. It's in the documentation of when it was sent back. I don't think it was, I didn't read it as being 100% clear of exactly when it came back, but counsel will probably have that on the tip
Right,
of
I
their
mean,
tongue.
it should show, I guess, when the lab got it.
Sure.
And then obviously we know when it came back. And so then we would know the delay, at least in getting it there.
Sure.
Okay,
But, yeah.
all right.
But it was delayed. Again, we're not disputing that that occurred. That occurred.
Right.
But moving sort of beyond, okay, we've got these reasons. The court looks at that. And the court, I think, balances, the trial court balances, hey, under Barco or whatever, at some point, yeah, the state has to bear some responsibility for prosecuting cases. That's pretty clear. It's clear in the case law. But if we're going to, that's true in every case is what I'm saying. So it leaves you with either A, this circumstance where you have to say, well, in every single case, no matter what else happens, we just have to weigh that against the state, which I don't think is really what the courts want to say. We do know that the courts have to look at it and go, well, first and foremost, is this a deliberate attempt on the part of the state to prejudice this defendant? In other words, hey, I don't know if he's guilty or not, but he's a bad guy. We're going to throw him in jail and make him sit there for 10 years. Clearly, the state's probably never going to prevail on a case where the state's knowingly and intentionally doing this, delaying a case specifically to prejudice a defendant. That's not what happened in this case, and it's very clear. The DA and his attorney were working on this case all along. They knew it was out there. They were talking about pleas. This is a case that's existing in the framework of the other cases. They're prioritizing their caseload in this county that we know is heavy. Again, where there's cases that need to be tried because a person's saying, I want a trial. This is not for plea or otherwise. Those things are having to get moved. But then we have this circumstance where negligence. Okay, well, the court found that, or at least suggested that. There's no evidence of neglect here. They weren't neglecting the case. They knew the case was there. They were talking to the defense attorney. The case was moving along.
Counselor, you started off saying, this DA said, I don't put cases on just because. And at best, that would mean you would do case management or status conferences to bring back to the court's attention the delay, the whole delay issues. And the court would then have an opportunity to push the attorneys into, is this for trial, or are you going to negotiate this thing out? But what sticks with me is the first sentence that you said, well, the DA said, I don't put cases on unless I know it's going for trial or something else. So how is that not negligent?
Well, I don't think it's negligent at all. I think that is case management by saying to the defense counsel, if the case is progressing, which it was, they're talking about plea agreements and otherwise all along, and you don't want it on a calendar, why would we put it on there? We're still working on the case. There's nothing to discuss. There's plenty of other cases that can take up that time on those admin calendars that require more discussion.
But that deprived the court of an opportunity to be the hall monitor or the one entity in the room to say, hey, fellas, is this for trial or what are we doing here? To give the court an opportunity to bring the speedy trial issues.
And I think that also cuts against the defendant, where the defendant knows that he can ask for it to be put on there. And if he's not asking for it to be put on there, I think that's suggestive that he does not want to try the case.
But then that's still putting the burden back into the hands of a defendant who is making every effort to contact any court that will listen to him. Hey, I don't know what's going on. I haven't talked to my attorney. You've got the weight of the state versus the defendant sitting in jail for over 2,000 days, and then you say, well, he didn't want a trial. At some point, somebody wants a trial.
The defendant in this case was represented by counsel the entire time.
And so was the state.
Sure. And defendant in this case, the testimony, of course, was that he had regular access to a phone. But he's calling, he's saying, I don't know what's going on. If only there was a way I could find out what was going on with my case. But he doesn't call his attorney. The defendant here calls, his aunt. He calls, various people. All that's in the record. But what's interesting is, in his filings in the federal court, he even says, when I talked to my attorney 2 years ago, we know to some extent he is conversing with his representation. He said it in his own filings when I talked to my attorney 2 years ago. I don't understand how, in one sense, we can come in and say, well, he never talked to his attorney for 5 years, or he never met with his attorney. Well, he maybe didn't physically meet with Mr. Davis, but it's clear from his own words that he's spoken to his counsel, and he spoke to his counsel about plea agreements. That's right there in his own words. If there may well be some issues potentially in an ineffective assistance of counsel claim, if he wishes to make the proper allegations and delve into whether there were conversations and what they covered and how extensive they were, etc. But here, we know he had talked to his attorney. We know the plea agreements were part of that because he words that in his own words in those filings.
So does the state just get to sit and wait for the defendant to keep giving potential plea agreement possibilities and just not put it on the case calendar and goes and goes and goes? Isn't that sort of like making the defendant plea himself out, or he's never going to get tried?
Well, I think that goes back to, number one, as the courts have said, the length of the delay in and of itself is not dispositive. And again, I think if the defendant is still asking for a plea, I think that weighs against him. I definitely think that goes to the fact of, do you violate a right that a person doesn't intend?
So it weighs against the defendant to offer a plea.
If the defendant is still seeking a plea agreement and isn't saying, hey, I want a trial, then I think that's some weight against him, because he's not.
Why?
Well, because the defendant here, if the defendant says, look, I want a trial, then at this point, he may well eclipse a plea agreement at that point. I mean, what is he looking for here?
But again, the defendant can negotiate a plea while the case is on the calendar for trial, correct?
Sure,
And oftentimes, that's what makes it ultimately settle, correct?
Well,
It's on the calendar.
Absolutely. But this, to me, goes back to, again, he's not asserting the right. He doesn't want to push this to a trial because if it goes to a trial, he's been told, we're going to do the violent habitual felon and this, that, and the other. They know that's out there from a very early moment. This is not something that was hidden. It's not something that was sprung. His attorney knew, hey, if we do this, we're going to, we've got him for other things.
So does the state have any, obviously, we know the prosecutor controls the calendar, basically, in criminal court. Does the state have any responsibility at all to, try to make sure things, let's say, for example, to give you a silly hypothetical, all right, let's say you've got a defendant who's charged with some serious felony, and he's sitting in jail, and let's say his attorney just is not doing anything. I'm not getting into the ineffective assistance counsel issues, but let's just assume he's got a sorry attorney, okay? Or a very busy attorney, and nothing has happened. Years go by, 2, 3, 4 years go by, and this DA he's not gonna do anything if there's nothing going on, and they don't have status conferences, they don't have an administrative calendar, and nothing happens. Maybe the guy writes some letters to some people, but we're not going to count letters. How long does he sit there?
Well, in a situation like that, I think there's going to come a point where the court is then going to weigh that more heavily against the state.
Right, but does the state have any responsibility to try to make sure that doesn't happen by maybe having an administrative calendar or something like that?
But that's also precisely what the state did. After that July of 2015 status, shortly after that, that's what the testimony was by Assistant District Attorney Poplar. He says, hey, look, we've got all these murder cases, I've got these things. It appears to me his case is becoming one of my older jail cases. We got to do something. And so they did that. They said, hey, bring in the conference of DAs, let them handle it, because I've got Carlisle and Turner and Johnson and whatever. The state made that determination where they said, I'm paraphrasing this, of course, but basically they're sitting there and they're going, okay, he's still wheedling on about, a plea, or he's not doing anything or whatever. Okay, fine. I've got to do something, and that's what they did. They gave it over to the Conference of DAs with other cases. The Conference of DAs came in and said, okay, here's a plea. Again, over that course of time where they go, how much time are we talking about in plea? And then we're going to make a formal plea offer, and if you don't take it, we're done. We're going to trial. And they had this sort of deadline there where and of course, there's testimony. He's then going and actually meeting with Mr. Farook, Mr. Davis is, to discuss, hey, this is the last plea. They go around, they can't come together. And at that point, it then gets complicated in that Mr. Davis says, okay, after discussions with him, he's now elected this month to go to trial. So that's when he decides he wants a trial, according to that. He withdraws. And then, of course, you have Mr. Bingham, who's there a short period of time. He is asked to recuse. Mr. Cease comes on board. And he's tried, I think, we're very close to a year after Mr. Cease comes on board, a year and 2 months, or somewhere kind of in that range, 3 months or something. And he's never asserted that right, and that's the other thing. Even though he's represented by counsel, we presume his counsel's working on his behalf. We can't, I don't think the presumption can be that these attorneys, when you haven't pointed, you haven't gone in and sort of taken issue. And even Barker versus Wingo talks about that, where you're not complaining about what your counsel's done here, then it's hard for us to weigh that against the state. And it's going to be hard for you to prevail. And it's very clear that failure to assert that right is going to weigh against you heavily.
So with the letters that he sent and the things he sent to the federal court and whatever, and the things that the DA was aware of, do they have just no relevance at all because they're not formal motions?
Well, the finder of fact in this case, the trial court, didn't make findings of fact saying, hey, he's looking for whatever. It didn't. And I think that that in and of itself is telling, is that the finder of fact heard that and didn't give it weight.
Well,
Again,
yeah, so, but I'm like, why why would that have no weight? Now, I mean, I realize, obviously, people in jail send letters sometimes. We've seen those before. But when, with sending the stuff to the federal court, and like I said, the things that ended up getting copied, to the DA, just so they're like, hey, just so you know, just doesn't count at all.
because when you read those, I think the fair reading of those is what he's complaining about is he's saying, hey, I'm sitting here without a plea agreement. Not, I want a trial, I'm innocent. He's saying, I'm sitting here, I've been here, and they won't give me a plea agreement. There's one of them where it's like, well, they're not, I don't have my discovery, or I haven't given me my discovery. He's talking about due process in the sense of, he goes, well, there was racial discrimination against me because I was arrested by a black highway patrolman, but the two white highway patrolmen were the ones that spoke to the magistrate. He's talking about, my bond is too high. He's not saying, I'm innocent, I want a trial, the states, he's not doing
Well,
that.
he is complaining about the fact that he's been sitting in jail for a long time.
But the
Delay.
reason.
I mean, I realize he's raising lots of other issues as well, but.
But he doesn't say, I want a trial. He doesn't say, what he's complaining about, I believe, is the fact that I want a plea, I want a lower bond, I want to complain. And interestingly enough, he says in there, I'm in jail with no evidence. That's his complaint. There's no evidence. Well, when we get into the prejudice, if I have time to get into the prejudice argument here, at the end of and I think I need to at this point, when we look at the prejudice issue, in the trial court, again, I think properly said this, it's rebutted, and here's why. If you take a case like Doggett, for instance, where a person has this drug case, 8.5 years, there's evidence in the record, he doesn't even know he's been indicted the whole time, and at some point, in the court in that one found this is completely negligent. They absolutely missed all these things. That's where you're going in Doggett. And the issue and why Doggett arises is because the state, after all of that, says, well, he can't prove actual prejudice. And that's where Doggett's like, oh, wait a minute. This was all your negligence. This was an extremely long time. He didn't even know he was under indictment, so he himself couldn't do any investigation or anything. Well, let's contrast that with this case. In this case here, the evidence was so strong that the defendant admitted to it. He stipulated, I was driving the car. I was driving while my license was revoked for an impaired offense. I was driving at the collision. It's my car, the gold Saturn or whatever. The people died as a result of that collision where I was driving, and I left the scene. He admitted to all of the factual evidence here. It's very difficult. Really what was left in this case really was the mens rea portion of it. Again, the malice, and probably won't have much time to do the Harbison thing, but I will get to it if you give me a moment. But again, in this instance, he can't show actual prejudice because there's nothing there that he could have lost. He admitted to everything, and he stipulated to everything, which forms the basis of this Harbison argument. And he was advised, again, he had a Harbison thing about it before he did that. He's admitted to all the facts that make up the sort of crux core of this case. He can't pop up and say, well, maybe there was someone else that did it that I couldn't find. But no. He knew all along it was him. Everybody did. And he also stipulated that the DNA was his. He stipulated the whole case. And I think that's critical because here is where you distinguish yourself from Doggett, where not only has the state shown, or not only has he not shown not only has he not been able to show any actual prejudice, there's even evidence there that sort of rebuts that there would be a presumption of the prejudice for him to prepare a defense because he admitted everything. And so in that instance, the prejudice portion of this is at best, very light against the state. Because again, how is he prejudiced? The presumption of prejudice. Now, they're going to say, well, he's been in jail for 6 years or whatever. Again, some of that was addressed. Now, I am not here to tell this court that sitting in jail is a weekend at a resort. I'm not. That's not what I'm trying to say. But what I am saying is, if you're a trial court judge and you're having to weigh out this sort of presumptive prejudice based on a person being in jail, it seems to me that a person who has spent 34 out of the last 41 years in jail is going to have a different weight assigned than perhaps a person who's in there that's maybe never been to jail before. I think you're going to have to look at those issues of, again, a person who's in there that long. This is where Doggett's talking about, well, as it gets longer, it gets more acute. But where there's no dispute as to the evidence, where you did it, that prejudice is, if it's not nil, it's very light. And again, the court properly found its findings of fact on all of these things are in fact supported by the evidence. The court properly weighed that. What I want to say real quick with regard to the Harbison.
And I'll give you a couple of minutes, 2 minutes, since we asked a lot of questions.
Sure. What I wanted to mention about that, and the state took I took a very interesting approach in this that you probably want to know about, and that's specifically that we have this circumstance where Harbison is out there. And Harbison, of course, says it's per se negligence, where you plead your client guilty without their knowledge, or you make these admissions without your client's knowledge and consent. What you had in this case, which makes it different, is you had two different sort of violations or alleged violations here. One is the misdemeanor death by motor vehicle, which he basically stipulated to all of the elements of that. That was covered by a Harbison conference. And then, of course, you look at the jury instructions where they say, hey, if you find these elements, we're sort of arguing that we believe what he did in this case, where he stipulated basically to all those elements, is the functional equivalent of the Harbison inquiry of that is the functional equivalent of it was okay. We didn't violate Harbison. They covered that in the stipulations, and then when probably the attorney does that in the closing, it's what's expected because they'd already covered that. In the hit and run, I have to clarify and make, in case it's not clear, in the hit and run, the defendant did not stipulate to the second element about knowing that there was injury. So I believe you have a more pure Harbison sort of issue in that claim. So what we said is, hey, we're noticing there's these cases like Malachi that are saying, in these constitutional style cases, it shouldn't be a per se standard. Now, that being said, obviously, and in all candor to this court, our Supreme Court has not overruled Harbison, but we have to say, I don't concede the issue. I don't think this should be a per se standard. But by that same token, I have to be candid with this court that the Supreme Court has, to my knowledge, not overturned Harbison as of today.
It is a per se standard, correct? It's just whether there was an inference that there was a stipulation to...
Harbison is a per se.
Yeah, and Malachi is a per se, correct?
Yes.
And it makes it easier to make a Harbison claim, not harder, correct?
Well, what I'm saying is, I think that the courts should address whether a Harbison claim should or should not be per se, based on the fact that there's these cases coming out that are sort of questionable.
And this court can't overrule Harbison and Malachi,
You cannot
correct?
overrule Harbison.
So it is a per se standard if there was, in fact, an admission of guilt, correct?
Harbison says that it is a per se.
Yeah,
And
Malachi, okay.
I can't argue. I'm just saying we think that the courts need to address that. Whether you think sort of twofold. Number one, in this particular instance, that the misdemeanor death by motor vehicle is not a Harbison issue based on the fact that there was stipulation to the essential elements, et cetera. And he was advised, he was in court, the judge asked, it was great. But on the other, I have to be candid with the court, they did not stipulate every element of the hit and run that he sort of threw out there. It's weird the way he said it, but if you read where he does it in the closing arguments, he said what he said. But so in that regard, if I may close very quickly, just to sort of sum up, I think the trial court properly weighed it out. You have neutral factors for the delay. You have zero showing of prejudice. The presumptive prejudice is rebutted, as we talked about, and he never asserted it. And if he wants to go into why he didn't assert it, that's for a different day. But there's no evidence that he ever asserted it, and therefore that weighs against him heavily. Trial court got it right. I'd ask this court to so uphold. Thank you for your time today. I'll just reset.
And since he had an additional, basically 4 minutes, I'll give you an additional 4 minutes as well if you need it.
Hopefully not, Your Honor.
We've asked a lot of questions, so.
Just to address Harbison, since my colleague got into that. As you're all aware, the Harbison inquiry involves two questions. The first is whether trial counsel conceded the defendant's guilt and whether he did so with the client's informed consent. In this case, there is no dispute that trial counsel explicitly asked the jury to find Mr. Farook guilty of misdemeanor death by vehicle and misdemeanor hit and run. The state argues, however, that Mr. Farook's consent can be inferred from his pretrial stipulations. Now, while it's true that Mr. Farook did concede certain elements prior to trial, there are two reasons why those stipulations do not authorize counsel's later concession of guilt. First, those concessions did not add up to a complete offense. The state concedes that as to misdemeanor hit and run, not all of those elements were addressed. I would also argue that as to misdemeanor death by vehicle, those elements were also not addressed. The four elements of misdemeanor death by vehicle are that the defendant intentionally caused the death of another person while engaged in the violation of the law, and that this violation proximately resulted in death. And there are three important things here. On the first element, Mr. Farook made no statement about what intent he did or didn't have. On the third element, the only violation that Mr. Farook admitted to was driving while license revoked, but in closing, counsel also admitted to driving left of center, and that was not authorized. And finally, as to the fourth element, while Mr. Farook conceded that the crash caused the Joneses' deaths, he did not concede that his own actions were the proximate cause of death. But counsel did there make such a concession in closing. But second, even if these concessions considered together do amount to a completed offense, there's nothing in the record to establish that Mr. Farook understood that to be the case. Harbison clearly requires that the defendant be fully apprised of the consequences of his actions. And here I would encourage the court to compare the colloquy when Mr. Farook entered his plea of guilty to driving while license revoked with the colloquy that occurred when his stipulations were entered. The stipulations colloquy establishes that he's given permission for his attorney to concede these facts, and that he understands that means the state doesn't have to prove those facts. But it doesn't establish that what he's doing is the equivalent of admitting guilt. And it doesn't establish that he understood what rights he would waive by admitting guilt to those offenses. And finally, I would urge this court to pay particular attention to Moretti. That's also a vehicular second-degree homicide case. It involves consent to certain facts and even consent to an overall trial strategy, but still finds that counsel must obtain his client's explicit and informed consent before making any concessions of guilt. Because the record in this case does not clearly show whether Mr. Farook understood and consented to counsel's concessions of guilt, if Mr. Farook receives no other relief, the case should be remanded for an evidentiary hearing. As to the state's arguments about Malachi, just make a couple of quick observations. First, that's a case about jury instructions. Obviously, in no way can it reasonably read to overrule Harbison. All the cases decided by this court and the Supreme Court since Malachi continue to apply Harbison as written. Second, as the state has acknowledged, this court cannot overrule a decision of the Supreme Court, nor can it rule in a manner contrary to its own precedent. And third, I would point to the U.S. Supreme Court of McCoy versus Louisiana. Now, that's obviously a different context. That's a capital case. But some of the rationale of McCoy applies here. In that case, defense counsel overrode the client's desire to pursue an alibi defense, instead admitted that the client was guilty of the murder in order to retain credibility with the jury for sentencing in hopes of getting a life sentence for his client. The Supreme Court said you can't do that. But what the court says is that per se relief is appropriate in that context because what is at stake is the client's autonomy, not counsel's competence. And structural error should apply when something larger than the individual's guilt or innocence is at issue. At issue here is the fundamental right of all defendants to decide the objective of their defense. Structural error also applies when the impact is difficult to measure or cuts at fundamental fairness, because a jury will almost always be swayed by a lawyer's declaration that his own client is guilty. The very last thing that I want to say today, Your Honors, assuming there are no more questions, I want to acknowledge that next week is the 12-year anniversary of the events giving rise to this case. Out of respect for all the parties, and in particular both families, and in the interest of the judicial economy, I want to ask this court, regardless of whether you find relief for Mr. Farook on any individual issue, to please reach all three so that the litigation might not be further protracted any longer than necessary. Thank you.
Thank you. Thank y'all very much for your arguments.
Thank you.
And we will adjourn.
At some point, one of the two of us needs to figure out what is the record for the most time a criminal case has been argued.
We might be going for it. I don't know.